Thank you, Chairman. Good to see you all again. I seem to be wearing many hats at this convention, but I think today I'm here in my capacity as a constitutional lawyer, and I was formerly legal advisor to the Oireachtas, so I had a fair amount of experience of these things, although I would always defer to the actual members of the Oireachtas themselves on many parliamentary matters. I don't have slides today, but I have given you a briefing note, and the headings are set out in the briefing note there. And I'll just mention the sort of 5 main areas that I'd like to look at today. The first is government responsibility to the Dáil. The second is the extent of modern government. The third is parliamentary procedures and parliamentary resources. The fourth is the Dáil committees. And the fifth then is some of the EU aspects. And really what I'm trying to do is not to come up with a shopping list of suggestions for Dáil reform, because many of the speakers today will be making those kind of suggestions to you, but rather to describe the constitutional framework. And I suppose I'll be there as well to answer questions as to whether particular recommendations you might like to make require constitutional change themselves or could alternatively be made within the current constitutional text. Okay, so to the first topic then, government responsibility to the Dáil. Article 28(4)(1) of the Constitution says, as you know, that the government shall be responsible to Dáil Éireann. This is the theory at least, but in reality, at least in normal times of political stability, the government controls the Dáil because there is a majority there. And 2 aspects of Article 28(4)(1 which have been teased out in court cases and so on are collective responsibility and individual ministerial responsibility. The primary doctrine really is that of collective responsibility. In other words, the whole government, the whole cabinet, if you like, is responsible en bloc to the Dáil. And the government tends to pull together, therefore, and the ministers serving in cabinet defend each other, if you like. So basically, the government sort of stands or falls by its own decisions as a group. And I mean, there are a lot of advantages to collective responsibility. It enables clear, firm decision-making in a group consisting of 15 members in the cabinet. On the other hand, there is this doctrine of individual ministerial responsibility as well, which it is acknowledged as part of our system, but is not actually expressly stated in the Constitution. However, it was a constitutional convention or tradition, if you like, which we inherited from Westminster, and does appear in a kind of a weak form in our constitutional system. And the idea there is that if a minister commits like a very serious error, it could be an error of misjudgment or policy or some personal misadventure, basically, the minister may well have to resign himself and can't expect the government to stand by him or her. But I suppose in reality, the collective responsibility doctrine does tend to trump the individual ministerial responsibility in our system. And I set out some quotations there from David Quinn Morgan, where he explains that often you will have, say, for example, government backbenchers who may want to call for the removal of a particular minister, but in fact the government tends to pull its weight behind that minister, and therefore collective responsibility tends to win out. An example of where that happened in our history was when President Carúla Dálaigh resigned, and the reason he had to resign was as a result of some very intemperate remarks made by a particular minister, the Minister for Defence, about the President at the time. And curiously, in that case, instead of asking the minister to resign, the government actually stood by the minister and said it was a matter for the government, not for the minister, even though it was purely his own remarks that were at issue. And ultimately, that led to the president himself feeling he had to resign because the government hadn't actually sided with the president in that particular case. But you do get occasional, very occasional instances in Irish history, such as where Haughey and Blaney were alleged to be involved in the arms trial issues, and there the government actually distanced themselves from the behaviour of those 2 ministers. So why am I discussing this today? Well, in fact, some submissions to the Constitutional Convention, in particular from Donald O'Brolchain and others, have suggested that in order to have true ministerial responsibility, we really need to move to a situation where ministers aren't members of the Dáil at all. And they propose quite a radical system, O'Brolchain and others, and they actually suggest that we should move to something along the lines of the US model or even the EU model, where the sort of key members of the executive, such as, say, the Commission in the case of the EU, are actually separate from Parliament. And by separating out the executive, if you like, from the Dáil, the idea is that you'd have true accountability then, because there'd be less sort of cooperation, if you like, between the two branches, and that the members, the representative house of Parliament would actually call to account the executive. So that's a suggestion that's before you, but just to remind you, you have already made some suggestions in this area in the report on electoral reform, where you suggested that there should be some external ministers who were not members of Parliament, at least some. So let's say we continue with the current system whereby the members of the government are members of Parliament. Are there any changes we could make there to enhance ministerial individual accountability? And I think in that regard, there are various changes that could be made in standing orders. And indeed, the former Clerk of the Dáil, as our chairman was saying, will be here this afternoon. He's an expert in that area and he may have some interesting suggestions to make there. But certainly all of those changes could be made without changing the fundamentals of the Constitution. Some suggestions, I suppose, I've seen over the years have been that there might be a kind of a duty of candour or a duty of honesty on ministers when they're answering parliamentary questions, and that could somehow be enforced by the Committee on Procedure and Privileges in the Dáil. But that would be quite difficult, I think, to work. I think it's a very interesting idea. But the idea, in other words, that a minister can't give a completely dishonest answer to a parliamentary question and just get away with it. So that's just one issue. Another idea would be that when answering a parliamentary question, if there are written materials which are fundamental to that answer, that the minister might somehow have to provide those materials in the same way as in a court. If a witness is being questioned, they might have to indicate what, if any, documents their answer was based on. That, again, could be very cumbersome, of course, to enforce. And, I mean, government departments mightn't like the way their smooth running would be affected by all of the need to provide documentation and so on. So we have to be mindful that calls for accountability of ministers have to be balanced against the smooth running of government departments on a day-to-day basis as well. Okay, just on to my second heading then, the reach of modern government. Article 28.2 of the Constitution says that the executive power of the state shall be exercised by or on the authority of the government. So in reality, the government and the ministers and their departments do not nowadays exercise all of the executive power. A lot of the executive power is devolved onto agencies such as various semi-state bodies and so on. And you'll be familiar with various controversies like the dividing line between the Department of Health and the HSE, for example. When issues arise concerning our health services, is the minister to blame? Are the senior civil servants to blame? Or is the HSE to blame, and so on? And it's hard to actually pinpoint where the responsibility lies. And it is arguable, I suppose, that the Dáil and the Oireachtas generally hasn't really reformed its own methods enough, especially in the committees, for actually calling agencies to account. And furthermore, there's a question to be asked as to whether, in certain circumstances, ministers should be brought in with particular agencies which are under the remit of their department, because sometimes it can be hard to figure out if the failure is actually one of overall policy or whether it's to do with the administration run by the particular agency at issue. So there's certainly some room for improvement there, and indeed Murish himself, Murish McCormick, has made some suggestions before that there needs to be more coordination between Oireachtas committees there, especially on cross-cutting issues. You know, for example, you could have environmental matters which fall under the remit of the Department of Agriculture, as well as the Department of Health, as well as the Department of the Environment. And are the Oireachtas committees really geared up to bring in the right people when they have questions in these areas? That's a question we can look at. But again, that particular reform wouldn't need constitutional change. On to my third heading then, and you'll hear a lot about this today, parliamentary procedures and parliamentary resources. As Murish mentioned earlier, a fundamental constitutional point is in Article 1510, where it is specified that the Dáil is master of its own procedures. So basically, the Dáil can devise any rules it wants for regulating debate within the House. And it's essentially a political forum, and it has to have these rules in order to run efficiently. But those rules can be changed. But of course, you'd need a government majority to do so. But there's certainly a lot of room for changing those rules to maybe enhance government accountability to the Dáil. And I mentioned some of the issues with those rules there. And likewise with resources. I mean, some people have suggested that committee chairs should be seen should be taken as seriously as ministers and should be remunerated as much and so on. And again, that's a resources issue. But of course, the Dáil controls resources, but in turn, those decisions are effectively controlled by government. Another example of where more resources might be used is with regard to private members' bills. I mean, most of the legislation in Ireland is actually initiated by the government, whereas in other countries such as Canada, a lot of legislation is initiated by private members or individual members who may be either part of the government party or the opposition parties, and they actually have a team of lawyers over there employed by the Parliament helping members to draft their bills and so on. So that's simply a resources question. Again, it's a matter for the Dáil, but ultimately then the Dáil is controlled by the government. Constitutional change wouldn't be needed in order to enact real change there. The fourth heading then, I mentioned Dáil committees. And committees aren't actually mentioned in the Constitution, but it's fairly obvious that the Parliament may effectively set up subgroups of Parliament to carry out its work, but they don't actually make final decisions. They merely make recommendations to Parliament. And precisely for this point, I think it's arguable that you could have at least some committees which didn't necessarily have a government majority on them. And for example, the PAC now, which is quite a strong committee, has traditionally been chaired by a member of the opposition. And that tends to make it a little bit more robust, I suppose, when calling government to account. But it's just an idea I throw out there that maybe the composition of committees could be looked at. Also, we have, of course, the whole area of parliamentary inquiries. In other words, when committees are carrying out investigations as such. And we have one of those looming on the horizon in the form of the banking inquiry. And that particular exercise should be an interesting example of whether, given our current constitutional structure, the Dáil committees are actually sufficiently empowered to carry out their purpose. And you will be, of course, familiar with the Abilara case, where the Supreme Court issued a major judgment on the powers of Oireachtas committees, and the judgment is quite restrictive. But I'll just point out several aspects of that, which, if you like, is the Supreme Court's interpretation of the Constitution. So as long as the Constitution stays the way it is, that judgment will stand. And what it basically says is that Oireachtas committees have no business really carrying out fact-finding inquiries, except where they might be finding facts about persons who were directly accountable to them. And then the question is, who is directly accountable to the Oireachtas, in particular the Dáil? Well, certainly ministers, and arguably as well senior civil servants, and arguably as well the heads of various state agencies. That is certainly the interpretation of the judgment that has been taken in the new Houses of the Oireachtas Act 2013, which will be the basis for the banking inquiry, if that goes ahead. As well as that sort of mainstay of the Abilara judgment, the Supreme Court also laid down other rules which do make it quite difficult for Oireachtas committees to plough on with their work. One of the problems is that they constantly have to relate all of the questions they ask to the functions, which, as I said, are quite restrictive. But as well as that, the Supreme Court set out very high standards of fair procedures which would have to be observed by Oireachtas inquiries. And frankly, these are the kind of procedures that take place, in court, and that's not the kind of maybe experience, if you like, that politicians would have in their day-to-day work of carrying out that type of cross-examination and so on. And furthermore, because of something known as the rule against bias, which means that if you're finding facts about a particular person or allocating blame, you shouldn't either have made statements in advance indicating what your position is, or you shouldn't have made up your mind in advance. In other words, you should be judging the situation freely and openly. But because of that rule, which the Supreme Court has said would apply to Oireachtas inquiries, politicians would tend to be very hemmed in by that rule, because with the whole media focus, which is constantly on Leinster House, and the sort of oxygen of publicity that politicians need to survive, it's asking a lot of them to expect them to not speak to media or anything during the course of, and indeed well in advance of, any inquiries. But in any event, as you know, the government did actually put this matter of possibly reversing the Abilara decision to the people in a referendum, and it was overruled. So we have the constitutional position, and if you like, the people have indicated in the referendum anyway that they're happy with that system, and therefore any changes, I suppose, that you'd be recommending then might be possibly within the constitutional system. So on to my fifth heading then, which is EU aspects. I mean, I could deliver a very long talk about all the sort of European Union or EU powers and the extent to which the Parliament, or the Dáil in particular, actually scrutinises the government work. I have mentioned one particular aspect in my briefing paper, and that's to do with an area where you have what's known as opt-ins. Across various parts of EU law, you have situations where, for example, Ireland might choose to opt into a particular measure. And in those cases, it's specified that there has to be prior approval by the Oireachtas. And it has been asked by many commentators as to whether there can actually be real prior approval if something is merely noted down on, say, a paper in an official document in the Houses of the Oireachtas, and members just note it and move on. Is that actually prior approval, or would there be some kind of requirement that this issue should be investigated properly, say in a committee first, and then the committee reporting to the Dáil? And likewise now, national parliaments have special powers, especially since the Lisbon Treaty, whereby they can actually send reasoned opinions to the EU institutions. For example, if they think that the EU is going beyond its remit in relation to a thing called subsidiarity and so on. Basically, a national parliament could actually send a document to the EU querying draft legislation that was promulgated by the EU. And the question again there is, like, is the Oireachtas, including the Dáil, is it actually equipped to do that under our current system? For example, in the UK, in both the House of Commons and the House of Lords, they have very, very good European Union scrutiny committees, which are staffed by teams of experts as well. And the reports they produce are absolutely excellent. But they actually have decided to appoint, teams of legal and other experts to help those European Union committees comment on the draft legislation coming from Europe. That's not so much a matter of government Dáil responsibility, but I think it's important to mention it all the same. And likewise as well, you have Oireachtas committees which are, scrutinising for example, the way in which Ireland votes on particular measures and so on. And sometimes they quiz the ministers or the civil servants before they go out and make the position clear. Sometimes they quiz them afterwards. But in fact, in my experience, it's quite rare that ministers come in to explain those kind of positions. It's much more common that civil servants come in. And again, we would want to maybe question why that is the case. So just to conclude then, I think I'm running out of time there. As I say, the constitutional theory and the constitutional reality are very different. And as a gentleman there said earlier, largely this is due to the whip system and the party system we have. And while I don't think that was envisaged by the drafters of the Constitution, on the other hand, I think it's just a reality that the Constitution has to allow political parties, because that's freedom of association. That's the way people do politics. And likewise, it would be very difficult to see how you could actually prevent people from having a party whip if that's something they voluntarily decide to adopt when they want to be a member of a particular group. So in conclusion then, I suppose I would say that while the Constitution is certainly not working to its full potential, I think that many of the reforms which you might like to suggest could actually be carried out within the Constitution if there were changes to parliamentary practice and so on. Thanks very much, Chairman.
Very good.